Hello, it's Jason Taylor with Speaking Truth to Power. Glad you're back joining us again. And, you've heard me speak recently about the importance of our voting for our justices in North Carolina. Not every state has the honor of being able to vote for your Supreme Court and appellate court justices and the other judges. And it's very important, and I've tried to share information about those justices. And a case came down just 4 days ago that I think helped tell some of the story. So I thought I'd share some of this with you, and you can kind of maybe understand it's the importance, and it goes along with what I was saying with regards to seat one. Seat one in the Supreme Court has got Justice Beasley and Justice Newby. I'm voting for Justice Beasley. I think she's an incredibly good justice, and I've complained about Justice Newby in that he is always for big government and big business, and when there's a divided court, you will always find him on that side instead of the side of the citizens of North Carolina applying the Constitution to protect their rights. So I'm good. This case came down 4 days ago, and I just thought it was perfect, so I thought I'd share it with you. So imagine, if you will, it's your grandmother, your 76-year-old grandmother, and she's not feeling well. She appears to have some infection maybe, and you take her to the hospital. And of course, she's 76. She has a little bit of a health history. She's been on let's say prednisone, a steroid type of medication, and maybe some other things. And they go in there, and the doctors see that she has, and they order a medication for her that is helpful with her symptoms, but the medication says, hey, in people over 60 years old who is on something like prednisone, you got to be very careful, because this can cause tendon ruptures, most frequently in the Achilles tendon, which you all know how bad that can be. And they treat her there at the hospital. They put her on this medication that they know can cause these problems. While the medication is helpful, right, and there's other ones that can be helpful, you have to juggle that with the potential risks here. Well, after she's done with her course of treatment there, and they're going to move her to a rehab facility, they maintain her on that medication, okay? And she goes on to the rehab place, and she's on this medication at the rehab place, and not surprisingly, she suffers a tendon rupture, which requires surgery, and ultimately she doesn't make it, and she passes from that, okay? So the issues that end up, the trial court here has this case come before it. The plaintiff, the estate of the deceased woman, brings this case, and they hire an expert out of Yale, from Yale, who's a doctor, who's an internist. And the doctors in question are hospitalists. Hospitalists are internists, like this guy, but they just work in the hospital, right? So the internist works in the hospital and out of the hospital, covers a bigger area, mostly out of the hospital, but spends months each year doing it in the hospital. All of them are internists, right? They're all board-certified internists. And the court says, because of the crazy laws that have been drafted by our legislature, most recently, in order to protect hospitals and doctors from being responsible for the harms they cause the citizens of North Carolina, right? Let me say that one more time. Our legislators created laws that make it hard for injured people to go after those who injure them, right? It protects the people who cause the harm, doctors and hospitals. And why would anybody do that? Well, money, right? Our legislators got money from the malpractice carriers and the hospital groups and the doctor groups, and as a way of saying thank you, they created legislation that makes it hard to go after the people who caused the injuries. And this was a great case for that, where the court sees this, and they say, the person bringing the case has to jump through all these hurdles. You have to hire these experts that meet these certain rules, and I'm going to get into that in this case. Okay? So understand, this gets at the trial court. The trial court says that the deceased woman's expert, A, isn't qualified to testify against the doctors, and B, did not forecast enough evidence that the conduct of the doctors was a proximate cause of the harm. Okay. Okay, so those are the two issues, and the deceased. So the case disappears, right? Because hey, you don't have a qualified expert, and he didn't forecast the evidence that caused the defendants caused the harm. Case over, and the plaintiff, the deceased woman's estate, appeals the case up to the Court of Appeals, and the Court of Appeals looks at it and says, I think the trial court was wrong. That expert that the deceased woman's estate hired is qualified in this case, and there was a forecast of evidence that it should be able to go forward to a jury. And the defendant who won at the trial court, who lost at the Court of Appeals, then says, well, I'm going to take it up to the Supreme Court and see what they say, all right? And the Supreme Court says, we agree with the Court of Appeals. All right, and I'm going to get into this a little bit for you because I think it's important. So the kind of the first issue here is Rule 702B. That's a rule of evidence, right? And the rule says basically, it says a lot more than this, but relevant in this particular case, it says three things that the plaintiff, the deceased woman's estate, has to do or show in order for their expert to be qualified, okay? And the first thing is that doctor must be a licensed healthcare provider in North Carolina or another state, which this doctor was. The second thing is that the doctor must have some specialty as the hospitalist or have a similar specialty. So if the doctor has a similar specialty, his specialty must include the performance of the procedure that is the subject of the complaint, and he must have prior experience treating patients similar to the plaintiff. So step two really has two parts to it, right? A, he has to be in the same specialty or a similar specialty, and he has to have experience treating patients similar to the one who is in the case. So in this case, this doctor is an internist. The expert that the deceased plaintiff hired, right? They hired an expert who is an internist. The three doctors for the hospital are internists who work in the hospital, so they're called hospitalists. So they're internists, he's an internist, so they're all internists, they're all board-certified internists. He works in and out of the hospital, they work just in the hospital. So his work encompasses their work. And he testified in his deposition that he regularly treated patients similar to the deceased woman in this case. And I will refer to her by name as I can as Miss Pierce. And her administrator is Raymond De Silva. So Mr. De Silva is bringing this case on behalf of Miss Pierce, and their expert is a licensed medical provider who is also an internist who several months of the year does it from the hospital, but always does it as an internist, just like these hospitalists. All right, and he's treated people similar to the plaintiff, and there was no testimony to the contrary of that. Okay, it's not like the other side. No, you haven't done that. You haven't done. They didn't deny that he had done that. That's not an issue. He had, in fact, treated similar patients. And the third issue that you have to show under this rule is that they must have devoted the majority of their professional time to either the active clinical practice of the same or similar specialty, as in this case, the hospitalist, and or the instruction of students in the same specialty during the year immediately preceding the plaintiff's hospitalization. See, these are some of the crazy rules that or laws that our legislators did to try to make it difficult for people to hold those who injure them accountable. See, they say, oh, you can't be a hired expert. If 2 years ago you retired and you wrote all the books on the subject matter, and you were the world's leading authority on that medical issue, you would not be qualified in North Carolina to give an opinion because you didn't spend the last year doing it. You spent the last 50 up until 2 years ago. You don't qualify. If you were the guy everybody in the world, or the woman everybody in the world went to, and you just retired 24 months ago, you wouldn't qualify in North Carolina. That's how ass backwards we are. That's our legislator trying to bend you over and have you scream Moon River, right? They're protecting the hospitals and the doctors from you being able to hold them accountable for the injuries they caused by their negligence. Not because stuff went wrong for no reason, because stuff happens, but they're negligent and they want to prevent you from being able to hold them accountable for that negligence. It's a ridiculous law and rules, but anyhow, we try to jump through these hurdles. And this doctor had done that. In the year before, he had been an internist, right? He had been doing this sort of thing. So the court determines that he qualifies to give an opinion on those three things. And therefore, he should be allowed to testify. The next issue then is whether he forecasted the evidence for a jury with regards to proximate cause. or causation. And he says, and I'm skipping through because I've kind of hit all this sort of stuff, but he had testified in his deposition that Levaquin can cause the tendons to rupture, that Mrs. Pierce had within the classic time frame and in the classic location, the Achilles tendon, and that it was his position that and they said, in addition to your opinions on standard of care, do you have an opinion, doctor, to a reasonable degree of medical certainty as to whether or not Miss Pierce suffered any injury that was proximately caused by being prescribed Levaquin when she's over the age of 60 and concomitantly taking a corticosteroid? And he says, yes, I have an opinion. And they say that is. And he says that she suffered a tendon rupture as a consequence of unsafe use of Levaquin because of her age and the steroid use. He answered the question. So they said, so that's forecasting the evidence. They asked him more questions on cross-examination, and he says different things, all not inconsistent, but they asked more questions, and he said, well, sure, other things are risk factors, but in his opinion, this was the issue. And it's best to avoid the longer you use this stuff, the worse it potentially is. So the Supreme Court said, yeah, you know what? He qualifies, and he's forecasted enough for it to get to a jury, for a jury to make a decision. Well, the dissent in here, the lone full dissent, Justice Davis concurs in part of the dissent, but the Justice Newby, he's always a dissenter on both of those issues. He says, in his opinion, that this doctor wasn't qualified and that the doctor did not forecast the evidence for it to go to the jury. He says that the court should have asked different questions. He says the hospitals diagnosed her with sepsis and that she was critically ill, and they noticed that Levaquin appeared to be helping, and they continued Levaquin prescriptions to treat the infection. And that she was, at the time she was transferred to the rehabilitation facility and was instructed to continue Levaquin along with her daily prednisone. He says, it was okay, that was working. What is missing here is that this is about getting it to the jury, right? If a person believes they were injured, or in this case killed, by the negligence of a doctor, and they hire an expert doctor, and that expert doctor should be able to testify for a jury of our peers to hear the case, right, and make that decision. If they're the same kind, if you're an internist and you hire an internist, you should be qualified. And if you have an opinion that what was done caused harm, it should go to a jury. The jury can decide whether that's accurate or not. The defense is going to have their own experts who probably disagree. So the jury's actually going to hear the facts of the case, experts from both sides, and what the law is, and apply it. This stuff is not meant to keep people from getting to court. You should be able to get to court. And 12 people ought to be able to hear the facts of what happened, weigh those experts, how good they sound, what their history is, how convincing they are, what their interpretations are, and make a decision. Justice Newby is trying to keep this from getting to a jury, right? Like our legislators were doing. They're all trying to keep your injuries from getting to a jury so 12 citizens can decide whether you ought to be compensated for your losses. This is wrong. We should not have stumbling blocks that prevent good, real, substantive cases of harm from getting to the jury for our peers to make a decision as to what should happen, if anything should happen, next. So this is an example of what I talked about. And the other thing I mentioned before is you can find these yourself. You can Google the cases, and you can read what the justices say. This isn't just me talking. Somebody asked me the other day, I was commenting about a politician, and I didn't like what they were saying, and I didn't have anything good to say about that politician. And an old friend of mine who I was talking with said, well, I'd like to know where you get your information. Well, where are you getting that information? I said, that politician's mouth. All you have to do is listen. I'm not getting a written story from somebody else. I'm watching them on television talk. right? I'm getting it from the horse's mouth. Well, you can get answers to these questions from the horse's mouth. They write these opinions and they put their name on it, right? So look it up. And remember, your vote counts. This could be you, your grandmother, your grandfather, some family member, and it's the application of law. It should not work as a hurdle against you getting into have the jury hear your case. If you should have experts, great, have experts. If they qualify, let's not find reasons to disqualify them. Let's not hunt till we can find some little splinter of something to suggest we hang them up on that. If you're an orthopedic surgeon, and I hire an orthopedic surgeon, should be good enough. We go further than that because we actually want to win the case, right? So you try to find the best, the most qualified people. And some people want to keep even, every case from ever getting to the jury if it involves protecting people's rights. If it might cost the big business or the government something, let the little guy suffer, right? That happens. It's real. And and I don't care whether you're a liberal or a conservative, on either side, you ought to want to protect the rights of individuals, right? Unless, of course, unless I'm talking to a business and you're not really a human being, right? Or you're some sort of computer and you don't really give a shit about what I'm saying. If you're a human and you're listening, you ought to be interested in protecting your rights. I wish you the best.